The market capitalization of the coin is used to summarize all that is taught in this video. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. Have a look at this for a moment. In the middle of the SEC appeal drama, Ripple reacts to the ruling regarding XRP sales. On the other hand, before we go any further, there is a brand new cryptocurrency airdrop that is currently taking place on Telegram and is set to start at any moment. I would ask that you make sure that you take part in this airdrop. Within the video's description is where you will find the link. Make sure you don't miss out on this opportunity. In the meantime, let's proceed with our video. Ripple Labs has submitted a Form C cross appeal to the United States Court of Appeals for the Second Circuit as part of its ongoing legal battle with the United States Securities and Exchange Commission (SEC). An attempt is being made by the company to reverse some of the rulings that the court has made in the past regarding certain institutional sales of XRP tokens. These sales were considered securities and were therefore subject to a fine of $125 million. The chief legal officer of Ripple, R.A. Alderode, emphasized that the appeal does not question the designation of XRP as a non-security, which was established in the July court ruling that was mentioned above. In the aforementioned cross-appeal, the interpretation of the 1933 Securities Act regarding XRP sales is being challenged. The dispute centers on the definition of the word investment contract, which typically refers to the buyer's right to profits generated by the seller's efforts or the termination of the seller's post-contractual obligations. The district court's interpretation of the 1933 Securities Act is being challenged. XRP is not sold for any buyer's account or at their request, according to the firm, which claims that it does not sell XRP. That the court's decision involved an excessively broad understanding of securities, and that neither of these conditions applied to the company's XRP sales. Furthermore, Ripple contests the court's interpretation of the Howey test, which is a legal criterion that was established in 1946 and is used to decide whether or not a transaction is considered to be a security. The company asserts that the court has a misunderstanding of the Howey framework's components pertaining to the investment of money and common enterprise operations. As a result of the fact that it functions within a decentralized system in which investor rewards are not primarily dependent on activity, XRP does not qualify for the securities classification that the court applied. The fair notice defense presented by Ripple is a challenge to the authority of the CSE Ripple, which especially underscores the need for unambiguous regulatory advice for businesses, has also been criticized for its proposed strategy by the Securities and Exchange Commission (SEC). In addition, the company contends that the only way it could have intentionally broken the rules was if it had received adequate guidance. In the event that Ripple's argument of fair notice is upheld, the cryptocurrency industry would be subject to enforcement actions based solely on the basis of fair notice. This would allow for the continuation of the problematic precedent of regulatory ambiguity. According to the pro-XRP attorney Jeremy Hogan, the fair notice argument that Ripple is presenting has the potential to dramatically diminish the enforcement authority of the SEC if it is successful. It is possible that regulators will offer cryptocurrency companies with more specific guidelines if the company is successful in the case. This could potentially result in the development of groundbreaking regulations for the enforcement of laws in the future. Taking this stance makes it abundantly evident that Ripple is of the opinion that regulatory organizations should make their guidelines easily accessible to the public and public. As an additional point of contention, Ripple takes issue with the injunction issued by the court, which urged the company to comply with the law in a manner that Ripple considers to be unclear. According to Ripple, the lack of clear norms makes compliance difficult, and the competition to comply with them increases legal risk and affects operational clarity. Ripple also says that the absence of clear norms makes compliance difficult. A precisely written injunction, as stated by the legal staff of the company, would provide the industry as well as the company with more stringent requirements. An XRP sales decision is being challenged by SEC. In addition, the SEC has challenged Ripple's programmatic XRP sales and employee distributions by submitting an appeal to the Second Circuit Court. The appeal is directed at Ripple. But when Analysis made the determination that the sales did not constitute violations of securities laws, the SEC once ruled that the decision should be overturned. There are allegations made by the SEC that Ripple's executives Chris Larson and Brad Garlinghouse assisted in promoting unregistered XRP sales. Ripple is opposed to these charges. When it comes to transactions involving cryptocurrencies, other CC needs to enhance its regulatory authority. In the event that the case brought by the CC is triumphant, it has the potential to become the first digital asset to be categorized as a security, which might potentially have an effect on the future token sales in the sector. Concerns have also been raised regarding the regulatory jurisdiction of the SEC and whether or not it will apply to all digital assets, a concept that has garnered a lot of attention during the course of this litigation. Due to the fact that Ripple has recently been discussing exchange-traded funds ETFs that are backed by XRP, XRP is still receiving interest in its ongoing expansion into new markets. It is significant that asset managers like Bitwise and Canary Capital continue to show interest in the company. Additionally, the continued interest that industry participants have shown in XRP lends credence to its legitimacy and widespread adoption in the cryptocurrency sector. Attorney John Deaton, a candidate for the Republican Senate and an advocate of cryptocurrency, has voiced his disapproval of the actions taken by the United States Securities and Exchange Commission (SEC) in the well-known case of SEC versus Ripple. In his capacity as an amicus curiae, Deaton is participating in the conflict on behalf of XRP holders. It is well known that he is a vocal opponent of the SEC, arguing that the actions of the SEC have resulted in significant financial losses for regular investors. Claims that have been made against Ripple by the SEC, according to the Securities and Exchange Commission (SEC), Ripple Labs has been accused of using its digital cryptocurrency XRP to provide unregistered securities. Additionally, the SEC has stated that Ripple would be required to register its sales with the SEC since, according to US law, XRP should be considered a securities. This case has prompted acrimonious disputes in the world of cryptocurrencies regarding the appropriate classification of digital assets and the restrictions that should be in place for them. Evaluations of the debt industry. Deaton criticizes the Securities and Exchange Commission (SEC) for what he calls gross overreach and abuse of power. According to him, the reaction of the market to the litigation is as follows. As a consequence of the actions taken by the SEC, investors in XRP have lost more than $15 billion as a result of the announcement. In a recent post on xrp+ripple, he brought attention to the ways in which activities in the government can be detrimental to private investors. Overreach on the part of the government should not result in the loss of your money. Moreover, Deaton referred to anomalies in the technique utilized by the SEC. It was stressed by him that the Securities and Exchange Commission had given its approval to Coinbase's business model during the firm's initial public offering IPO 2 years prior to taking legal action against the company for allegedly letting individuals to engage in illicit XRP transactions. The agency's goals and the processes by which decisions are made are called into doubt as a result of this contradiction. The function of the amicus council. There are around 75,000 people who own XRP, and they believe that their interests are not being adequately represented in the ongoing legal struggle. Deaton intends to provide these people a voice by acting as a amicus counsel. He is responsible for a number of responsibilities, including defending the rights of XRP holders throughout the legal process and filing remarks to the court on behalf of XRP holders. He emphasized this because he is dedicated to assisting average investors who are impacted by changes in regulatory policies. Unpaid, he is exerting himself in this manner. In recent statements, Deaton has made it abundantly plain that he would not retreat from his fight for XRP holders, regardless of the outcome of his political career. When he stated, "I don't walk away from what I started, regardless of whether or not I am running for Senate," it was clear that he was dedicated to the cause. There will be further repercussions for the regulation of cryptocurrencies. More important problems concerning the regulation of cryptocurrencies are raised as a result of Deaton's involvement in this case. A significant number of advocates are of the opinion that more specific legislation is necessary in order to protect common investors and to encourage innovation within corporations. Concerns expressed by Deaton are indicative of the fact that a significant number of individuals within the Bitcoin community believe that the existing laws are inadequate and, at times, overbearing. In response to these concerns, Deaton has asserted that he takes responsibility for what he considers to be fraudulent and has called for accountability within the SEC. He has also called for accountability to be held accountable. He is of the opinion that additional legal action will be taken against XRP investors as a consequence of the continuing examination into the activities of the SEC. In conclusion, the appointment of John Deaton as amicus counsel in the SEC v. Ripple case is an important development for those who possess XRP, as well as the greater cryptocurrency community. His severe criticism of the actions taken by the Securities and Exchange Commission (SEC) raises significant concerns about the extent of regulatory overreach and the effect it has on average investors. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated in the field.